Hello guys, welcome to this video. In this week's episode of administrative law, we are going to look at another case law. The case law that you're going to look today is the case of London Borough of Tower Hamlets versus Begum. So we will start by looking at the context of the case. So this case involved Begum. Begum is the plaintiff. She is a lady. We have the London Borough of Tower Hamlets, also the council. This was the defendant in this case. We also have the Court of Appeal, was the arbiter in this case. So this case took place in England in 2003. So why did the case take place? London Borough of Tower Hamlets did not entertain the application of the lady Begum for housing assistance. So Begum sought judicial review to help her understand the legal implications of the issue. So what is involved in this case is error of law, which is also known as an imprudent departure from the law. So let us now look at the case details closely. So the London Borough of Tower Hamlets, also known as the council, appealed against a decision by its owner, Judge Hornby, to allow an appeal by Riha Begum, the applicant. So the applicant, Mrs. Begum, filed an application against the council's decision not to entertain her application for housing assistance. Mrs. Begum, the applicant, had made a second application under the Housing Act of 1996 to the council on the basis that it was unreasonable for her to continue to reside at Mark House with her two children. The officer rejected the application on the grounds that there had been no material change in the applicant's circumstances. The applicant appealed the decision to the county court, which allowed the appeal. So let us look at the issue. The main issue was how a local housing authority should respond to a subsequent application under the Housing Act of 1996 from a person who had previously applied and had been granted temporary accommodation under the Act but had become homeless again. The council argued that a subsequent application could only be considered if there had been a material change in circumstances, while the applicant argued that the test was whether the accommodation previously offered was clearly unsuitable. So the case was taken to the Court of Appeal, and here is what the Court of Appeal held. The Court of Appeal dismissed the council's decision and allowed the applicant's appeal. The court held that the council had misdirected themselves in rejecting the applicant's second application on the basis that there had not been any material change in circumstances. The court also held that the test for subsequent application was not whether there had been a material change in circumstances, but whether the accommodation previously offered was clearly unsuitable. The court provided guidance on the application and approach the housing authority should adopt to subsequent applications. So, under the Housing Act of 1996, and stated that if no new facts were revealed in a subsequent application, the authority may reject it as incompetent. The court also held that the applicant was entitled to her costs. So now that we have looked at the case in details, let us now look at the significance of the case in the law. So one of these most important thing about this case is that it highlights the fact that error of law invalidates an administrative action. Also, in the same way, being unreasonable can invalidate an administrative action. Thank you for watching this video. Like, share, and